If there is any such thing as a norm, the main assets in the majority of cases are the family home, the former matrimonial home, and pensions, uh, both incredibly important. In terms of the family home, sometimes that property has to be preserved for the benefit of the spouse who is the main carer of the children. Sometimes the property will have to be sold because the financial scenario in the case requires it. Pensions is an extremely interesting subject, and up until relatively recently was quite badly overlooked. But pensions do have to be taken into account. And as a matter of law, where there is a divorce, where there's a decree absolute, the court has the power to make a pension sharing order. Pensions have to be very intensely looked into, and sometimes it is necessary to obtain a report from what's called an actuary. An actuary is a specialist in pensions and takes into account the actual pension asset and the life expectancy of the parties. Quite often in divorce cases, pension sharing orders are made, and the way that works in very simple terms is that a percentage is taken from one spouse's pension pot and transferred to the other spouse so that that spouse has a pension pot to be accessed when advised. Pension pot under current legislation cannot be accessed until age 55, at which point a tax-free lump sum can be taken from the pension and an income from the balance. There were, of course, some new pension rules brought in a year or so back which allowed for people to access the whole of their pension fund, and in the words of the minister at the time, buy a Lamborghini if they wish. But we would never recommend that. We would recommend instead that a client took independent financial advice about what to do with their pension funds and other assets.